This is Paul Turner, the Immigration Barrister at Imperium Chambers. Please subscribe to my channel and hit the notification button for all up-to-date immigration news. Today I'm going to give a further update on the 10 years continuous lawful residence and indefinite leave to remain applications. It seems that the 10 years continuous lawful residence route to indefinite leave to remain is getting a lot of attention in the courts recently, and quite a lot of it is quite positive. The law on getting indefinite leave to remain based on 10 years lawful residence, even if people have been accused of cheating or dishonesty in say, their English language tests, is pretty much settled. This means that people who have not had leave for over 6 years but have proved that the Home Office were in the wrong still qualify for indefinite leave to remain. This is essentially where they have been shown not to have cheated, and the courts have accepted this. We have successfully argued that these people should be put back into the position they were before the Home Office took the wrong decision against them. It follows the Court of Appeal case of Khan. We've used this to back up arguments and got ILR for a number of our clients, people that have been wrongly accused under Balajigari type cases, tax cases, and a lot of ETS cases where we've managed to get people indefinite leave to remain. Some of them we've even got them indefinite leave to remain without even going to court. If you think you might qualify, please get in touch with us urgently, as you may be suffering in silence or stuck on the wrong route to settlement. You may be on 2.5 years when you should be able to get indefinite leave to remain. I say this as yesterday somebody was on the 2.5 year route, but when I looked at the facts of their case, they clearly qualified for ILR several months ago. However, people who overstay for a short period of time after their visas are expired and then accepted are described as bookended overstayers. They have overstayed, but the Home Office have wiped out the overstaying. They're different to the ETS and Balajigari cases, but they also get indefinite leave to remain. However, there is a fly in the ointment, which is the case of Wasim, which was not a bookended overstaying case, but a case where he didn't have leave. And these are people where at the time of their ILR application their leave had run out, often sadly a few months short of 10 years. And the court said that argument wasn't going to work. However, that's not the end of the matter, as there may well be another way of getting you leave to remain. A little bit more detail about the case of Wasim. In it, it was argued that anyone that was not lawfully in the United Kingdom for 10 years could not rely on the 10 years continuous lawful residence, and that was an argument that was accepted by the court. However, as I've mentioned, there are many other routes to getting settlement. Wasim's lawyers tried to argue that this policy was too simplistic and ignored previous policies and human rights arguments that did not make sense, to overlook leave in the middle of a 10-year period but not at the end of it. Unfortunately, the upper tribunal were not convinced by this argument and rejected Wasim's contentions. This meant that people that essentially applied very often very close to the 10 years but didn't have leave at the time their ILR application was made were refused. However, this does not apply to people that have been wrongly accused under Balajigari, wrongly accused of ETS, even if they haven't had leave for 5, 6, 7 years, but then proved their innocence. And it doesn't apply to people who have had gaps that have been overlooked. So it is a complicated picture, and you may well qualify for indefinite leave to remain. And even if you don't qualify for indefinite leave to remain, I've often had clients that have come to me who actually have very good human rights claims based on family or their health or children, and we're able to put those forward and get them some sort of leave to remain and get them out of the hostile environment. So if you think you might qualify for indefinite leave to remain, get in touch. If you're concerned that you don't and you're worried about your immigration status, given the hostile environment, given Priti Patel's statements, please get in touch with me as soon as possible, and I will do my absolute best to try and get you sorted out, get you regularised in the United Kingdom, and get you some sort of visa. Thank you very much for watching this video. It's an update again. Further updates will come if the court issues further decisions, but this is an important case and it relates to the other cases of Asif and Hock. Thank you very much again for watching. Please stay safe. This is Paul Turner, the Immigration Barrister at Imperium Chambers.